Welcome once again to Lehto's Law. Here's Steve Lehto.
Tom sent me a note. It's Steve, I know you like those HOA stories, those stories about homeowners associations. And I got one here from Fox 2 Now. Chad Mira wrote this. St. Peter's HOA spends thousands suing homeowners for their fences. This is a story out of Missouri. A former homeowners association board member stepped down when she noticed that the HOA was paying thousands of dollars in legal fees over a couple of fences. She said, we're going to see about recalling that board, and then we're also going to step back and we're going to look at what we want to do long-term as a community. TV station reviewed financial documents for the past 5 years provided by this former board member, and they show that legal expenses went from $485 in 2020 to more than $31,000 in 2023. The former board member notes the rise coincides with those two lawsuits filed in 2022. The HOA is suing two homeowners for breaking the local rules, the HOA rules, that allow residents to only fence in their backyards. The defendants in this case have also fenced in their side yards, not their front yards, their side yards. In one of the lawsuits, a judge wrote that the HOA cited legal expenses at more than $20,000 and was still growing. The HOA president did not respond to an interview request, but wrote a letter to the community to address concerns circulating on social media and said, it is unfortunate that very few homeowners don't respect restrictions that we have all agreed to. It is our duty to enforce the declaration. We unfortunately have pending enforcement actions which are in litigation. While enforcement is always the very last option, it is expensive, and according to the enforcement section of our declaration, is recoverable, meaning that if they are forced to sue you and they win, you got to pay their attorney fees because it's built into the covenants. However, one judge has already ruled against that. In ruling in one of the lawsuits, a judge sided with the homeowners due to a lack of enforcement in other cases. In one cited example, the defendant lived right across the street from another property with a fenced-in side yard. The owner of that property had not been sued. And so this is always a question. If there's a rule on the books and it's not being enforced, and then somebody breaks the rule and they go, okay, we're going to start enforcing it now. It's kind of hard to make that argument with a straight face in court and say, this is a big problem, this is a big problem, when the other side can go, yeah, what about them, what about them? And selective enforcement itself can actually be a problem. So the judge also said the HOA can only recover legal fees if it is the prevailing party. So if they take someone to court and lose, they don't get their attorney fees reimbursed by the other party. They get, of course, paid for by the HOA. The case is still ongoing because the HOA is now appealing a ruling they didn't like. The attorney representing the homeowner in the case added the homeowners association in this case spent tens of thousands of dollars litigating a matter that could have been easily resolved by granting a minor variation from the restrictions, especially considering that numerous other properties in the subdivision already have fences that are out of compliance with the rules. And so it's kind of like, that cow has left the building, okay? As the legal fees pile up, the former board member noticed the HOA does not have an umbrella insurance policy, which is required by the rules and covenants and the declaration of trust that govern this HOA. So the HOA rules say, here's the rules you must live by. Oh, by the way, the association and the board have got to get an insurance policy to cover any legal issues. And so on the one hand, they're selectively enforcing rules, apparently. On the other hand, they haven't bothered to get the insurance policy to cover these things. And so she says, you've already spent the money. There's another one going to court in May for the same reason. You've already lost. At some point, you've got to stop the bleeding for this community. Now, the HOA addressed this in its letter, also stating, we do and have always had insurance on the property covering all common ground and physical property with a $2 million general liability policy. We have submitted an application to raise the limits of the policy to include an umbrella of $5 million, which is in underwriting. So the question is, does that cover legal actions brought by the board against its members? There are other questionable actions, though, according to the woman who stepped down from the board. She said, we have so many issues within this community that's what we're paying our reserves for and paying our fees. It's just, to me, mind-boggling. There's currently a petition circulating around the community, and if 20% of the homeowners sign it, it'll force the HOA to hold a public meeting to address their questions and concerns. And an attorney for the HOA shared a statement with Fox 2 saying, despite the association's best efforts to avoid litigation with multiple attempts to reach an amicable resolution, the association has 2 pending lawsuits against owners that are violating the covenants that they agreed upon when they purchased their home. As those lawsuits are pending, the board is not going to provide further comment. The attorney also stated that homeowners and the public are welcome to review the case online. It is surprising and unfortunate that several owners now want the board to ignore the covenants while alleging the board is violating the covenants and threatening lawsuits. The board, as it always has been, is committed to serving the community as a whole and will continue to do so. So the lawyer rightly points out that there's rules on the books and these people are breaking the rules. And that's really not the argument, though. The argument is a bunch of rules on the books, some of which weren't apparently being enforced. At least that's the argument. So somebody comes along and does something and says, well, technically it's against the rules, but other people are doing it or have done it. And the board says, no, you can't do that. And they ought to address, well, what about these people? Now, there's always the possibilities other people are grandfathered in for some reason, but that's not the point. The point is that you can't selectively enforce rules, and that would be a problem. Now, I will point out that if you are in a homeowners association governed place and you've got rules to live by and you want to build a fence or do something that looks like it contradicts the rules, however, other people are doing it or have done it, you've got a choice. 2 things you can do. One is you can live dangerously and do what you want to do and see what happens. And it might be that you luck out like the other people did and you don't get sued. On the other hand, they might go, oh, you know something? We weren't around, or different borders in place, or who knows what happened with those other people. However, you are clearly breaking the rule right now, and we're telling you to stop. At that point, your choice is, do you stop or do you litigate? Because you're going to get sued. And that's the question. And so a lot of people are going to say, but Steve, if I go into court and I can prove person across the street had that fence in their side yard, I get one too. And that's an automatic winner. It's not an automatic winner. A judge might rule in your favor, but it depends on the facts of the case. For all we know, that fence was installed 20 years ago, back when the rules allowed it. I mean, I don't know. There's always possibilities of other things out there that could radically change the outcome of this case. But what the woman at the heart of the story is talking about starts with the fact that they spent $31,000 in legal fees in 2023. And she says the bulk of that is 2 cases involving fences and a rule that they're trying to enforce against 2 homeowners when there are other people who've clearly broken that rule in the community. And the question then becomes, is this a rule that we want to enforce as an HOA? So one thing I pointed out before, and I know every time I do stories about HOAs, there's a whole bunch of people who weigh in. Some say, Steve, I live in an HOA and I love the thing. So there are people who are in favor of these. I've heard other people say HOA shouldn't exist, they should be abolished, or if you hear about them, run, but just never buy in an HOA. That's the other viewpoint. And if you do end up in an HOA, understand that it's run like its own little government. And there is a set of rules, covenants, whatever they call it in your state, that govern how it's run. And they're often incorporated directly into the title to the property, right into the deed. And so you can go read the rules, and it's going to say, here's how the HOA operates. Here are the rules. Here's how the board is created. Here's who runs it. Here's how often elections are held. Here's how elections are held. And there's a couple things you can do if you're in an HOA and you want change. You can try to get yourself on the board and become one of the people on the board who's got a voice in what happens. 2 is you can try to get the covenants changed, and that can be done also. So I don't know which will be easier. I've heard of HOAs or condos, condo associations. I knew of a condo association that had 4 members. It was a little building with 4 units in it, and they were a condominium, and they had a condo association. But they didn't have a distinct board because what do you do if you have a board of 3 people governing 4 people? And they literally, all four of them were on the board, and they'd meet once a year and hash things out. But I've also mentioned that I was on the condo association board, the condominium I lived in years ago. And I believe there were 176 units in that association. 176. And the amount of money that we were handling was quite large. Some of the contracts that we were entering into were quite large. And one of the reasons I got myself on the board is I was unhappy with some of the things the board had done previously. And me and a couple other people got ourselves elected to get in there and do what we could to straighten things out. And so one of the things you're going to discover over time is that condo boards often get complacent where they run the place and they kind of back off and don't really pay attention to anything. But then things can get out of control. Somebody can get on the board and go, hey, we're going to start enforcing the rules now. Well, what about all the people that didn't have the rules that enforced against them in the past? Well, that's in the past. Now is now. And so if you're in a situation like this, what you can do is agitate to either get on the board or get the board to change the rules, because most of the rules will say things like you can't do the following unless you get prior approval. And obviously, if you came to the board and said, I want approval to do this, I believe in many cases the board can say, yes, you can. We're going to grant you the right to do that. But you get that permission first. And so you go ahead and do it the other way. What do I like to say? Self-help is fraught with peril. And I stole that from a professor at law school. So you can use it too, though. So Tom, thanks for sending that. St. Peter's HOA, and again, that's in Missouri, spends thousands suing homeowners for their fences. From Fox 2 Now, that's Chad Miro writing that. Questions or comments, put them below this. Talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Does anyone else think it's wrong that only one company makes the game Monopoly?